Hi there, welcome to our Employment Law Update. My name's Lorna Gemmell. I'm the Employment Law and HR Training Manager for Law at Work, and I'm joined today by one of our senior solicitors, Kirsty Beattie. I'm sure many of you will have been to our face-to-face employment law updates across the country in the past, and for obvious reasons this time round we're restricted to webinar format. For those of you who have come along before, you're probably aware that our next set of employment law updates would typically be the spring. So you never know, we might be in a position by then where we're able to come out and see you face to face again. But hopefully in the meantime, this will be a useful substitute. The employment law update will take a similar format to what it would if we were face to face. We'll take you through the latest developments in employment law, and there'll be an opportunity to ask questions in the chat section throughout. We'll certainly have time for questions at the end, and just depending how we get on with our timings, we may pause for additional questions throughout the session. Hopefully you have located the chat function, and that's the best place for you to ask your questions. I'm going to share my slides just now, and I'll talk you through what we're going to cover today. So we're going to start off with a key case update, and my colleague Kirsty will take you through that. We'll tell you about some recent developments and also just highlight some Supreme Court judgments that we're waiting on at the moment. She'll then talk you through some coronavirus related themes. Obviously, coronavirus in itself is a large topic from an employment law perspective. So we're just going to speak today about the themes that we've identified our clients asking about over the last couple of months. And of course, there was a bit of a last minute scurry to update the slides in order to make sure that you're aware of the developments late last week in relation to the replacement for the furlough scheme. Kirsty will then hand back over to me, and I'll do a short spotlight on diversity in light of the Black Lives Matters movement. And then hopefully we'll have an opportunity for some questions at the end. So I'll hand over to Kirsty just now, who will start us off with a key case update.
Thank you, Lorna. So good morning, everyone. The first couple of cases I want to start with this morning both concern unfair dismissal. So if we start with K against L, this involved a teacher who was charged but ultimately not prosecuted for possessing indecent images of children on his laptop. So the charges were brought, but ultimately they were dropped because the court or the authorities couldn't be satisfied beyond all reasonable doubt how the images came to be on the laptop. And one of the defences that the teacher had put forward was that multiple people had access to this laptop and therefore could have been responsible for downloading them, including his teenage children and their friends. So many of you will know that where an allegation of misconduct has a sort of criminal aspect, the employer is not bound to arrive at the same conclusion as the court. And the reason for that is that the standards of proof required in both are quite different. So in the court, they have to be satisfied beyond all reasonable doubt that the crime took place. The disciplining manager in a disciplinary case just has to be satisfied on balance of probability. So it's more probable than not that the crime took place. Sorry, that the misconduct took place. In this case, everybody sort of accepted that the images were present on the laptop. But as I say, the teacher denied responsibility as to how they got there. So the disciplining manager had to decide, is it more probable than not that the teacher was responsible for downloading and then therefore possession of these images? And his findings were inconclusive on that point. He couldn't make a determination one way or the other whether it was more likely that the teacher had downloaded the images himself. But nevertheless, the disciplining manager decided to dismiss the teacher for misconduct, and that was based on both a risk to children and reputational damage. The teacher then brought a claim for unfair dismissal. The allegation, as it was, let me read it to you, in the investigation disciplinary invite letter, was that the teacher had been involved in a police investigation into illegal material of indecent child images on a computer found within your home and the relevance of this to your employment as a teacher. So as you can see from that investigation and disciplinary invite, there was no mention of reputational risk there. So when the claim was presented in the Employment Tribunal and latterly the EAT said, we uphold the unfair dismissal claim for two reasons. The first reason was that in a conduct case, and many of you will know this, but in a conduct case, the disciplining manager has to have a genuine belief that the misconduct took place. And the disciplining manager here had admitted he hadn't really come to that conclusion. As I say, his conclusions were he was inconclusive on that point. And importantly, he also flagged the EAT also flagged that reputational risk had never been mentioned up until the point that the employment was terminated, and anyone facing disciplinary allegations has to know the extent of those allegations. They have to be able to prepare to come in and defend themselves in full. They said that reputational risk could have been a relevant consideration, and it might even have been a fair reason to dismiss, but it's not misconduct. If reputational risk is the reason for dismissal, that comes under some other substantial reason, or SOSR, under the Employment Rights Act, but it hadn't been treated as such in the lead up to the dismissal, and that therefore meant that the dismissal was unfair. Okay. And the second case, again, is an unfair dismissal case, and this involved, before I start, I want to urge a little bit of caution in relation to this one, which for reasons I'll come on to explain. But this case involved a claimant, an employee with around 10 years service, Miss Gallagher. She was employed in a relatively senior position at Abellio, Scottville. And she and her manager had a reasonably challenging relationship. They'd had a couple of workplace disputes over things like on-call rotas, recruits into their team, pay, bonuses, kind of run-of-the-mill stuff, but the relationship was kind of accepted by both to have been impaired by that. They had tried to get, they'd had a couple of meetings to try and resolve these issues, but that hadn't been particularly successful. And Abellio was at a sort of critical juncture, and it determined that the relationship between these two employees was key at that stage. So quite unusually, Miss Gallagher was invited along to her annual appraisal, and her manager took the decision to dismiss her at that stage. And the reason for the dismissal was this fundamental, irretrievable breakdown in their working relationship. So ahead of the appraisal, Miss Gallagher hadn't been warned that it may end in termination of her employment. She didn't know, therefore, that she was fighting for her job. She hadn't been offered the right to be accompanied, and she wasn't given the right to appeal against that decision. So for anyone with a bit of employment law knowledge or experience, alarm bells will be ringing, because we know that a dismissal has to be substantively fair, i.e. there must be a fair reason to dismiss, but it also has to be procedurally fair, and it has to be reasonable sort of generally in all of the circumstances. So surprisingly, in that case, the EAT held that the dismissal was fair, and it said that it accepted that there had been a fundamental breakdown in the relationship, so there was a fair reason to dismiss, but it also accepted that this was a rare example of a case where actually following a dismissal procedure would have been futile, or would actually potentially have even made the matters worse. So it held, taking everything in the round, that dismissal was a reasonable response, that it was within the band of reasonable responses open to the employer in that case. And factors that were relevant to that included the fact that the manager, and I think Miss Gallagher herself, had prior to the dismissal been looking for alternative employment, and Miss Gallagher herself had accepted that the relationship was quite badly impaired, but had never really expressed much of an interest in trying to repair it. As I said at the outset, take that with a pinch of salt. It doesn't turn everything on its head that we know about procedurally fair or unfair dismissals. The EAT did remark that this was quite an unusual case, and that dismissals in the absence of any sort of formal procedure will always be subject to an additional degree of scrutiny by the tribunals. So those dismissals very much remain the exception rather than the rule. As Lorna said, if you have any questions about those cases, please do leave a comment in the comment box. The next two cases that I want to chat to you about involve employment status. It's one of those topics that kind of rears its head every time we do one of these updates. We just can't get away from it. And the first case I think is quite an interesting one, because City Sprint had a finding made against them in 2017 to the effect that those cycle couriers they had engaged as self-employed cycle couriers were actually in fact workers for the purposes of receiving the benefits that typically a worker would receive working under the Working Time Regs, Employment Rights Act, National Minimum Wage Act, things like that. So in response to that, City Sprint decided to sort of overhaul their terms and conditions and ensure that anyone that they engaged was a genuinely self-employed person. But despite that, a group of claimants decided to challenge their employment status again, even with the new terms and conditions. So in any employment status case, the tribunal will take note of the written terms and conditions, but will always look behind that at the reality of the working relationship as well. And in that case, the tribunal remarked that it recognised that City Sprint had introduced a right of substitution, which is akin to a sort of self-employed relationship. But in fact, that was never really exercised, and a kind of fundamental feature of the working relationship remained personal service. And that is something that you would expect in a relationship either of a worker or an employee. It also remarked that the couriers didn't market themselves as, independent cycle couriers on business of their own account. They were free to do that, but in fact they didn't. Again, that would be the type of thing you would expect from a genuinely self-employed person that just wasn't happening in this case. And they were satisfied, therefore, that despite the change in terms, that the individuals continued to be workers. And an interesting point on that case was that City Sprint had tried to be quite clever, and in the new terms they had included a clause that said any sums paid in the event that the individual is deemed to be entitled to holiday pay, sums already paid are deemed to have been already include holiday pay, so any holiday pay claim would therefore be null. But the tribunal made quite light work of that and said no, that there wasn't a sufficiently transparent holiday pay calculation or scheme. It wasn't set out separately in the pay slip as you would expect. So again, it didn't accept that holiday pay had already been paid to the individuals, and that was therefore due along with all the other rights that they were bringing claims in respect of. The second employment status case on the slide there involved a hairdressing apprentice. She, at the conclusion of her apprenticeship, was offered a contract with the same salon that she had completed her apprenticeship in. And the contract she was offered was an independent contract for services. So she was engaged as a self-employed hairdresser and not as an employee. And at the point that the salon closed, she tried to bring claims, multiple claims, unfair dismissal, sex discrimination, notice pay, holiday pay, redundancy, all the types of things that typically a self-employed person would not be eligible for. So the first question, therefore, for the tribunal as a sort of preliminary point was she entitled to bring these claims? What was her employment status effectively? Like in the last case, they'll look behind the independent contract for services and assess the relationship in reality. And in fact, the claimant, Miss Gorman, in that case, was under quite a significant degree of control by the salon. So her clients were allocated to her. She didn't have freedom to choose who her clients were, and their details were saved in a password-protected file that she didn't have access to. She was also subject to restrictions not only during her employment but for 12 months thereafter from working from a competitor. And restrictive covenants like that would be the type of thing you would expect in an employment contract, as opposed to one of somebody who's an independent, self-employed person who's free to take up business with whomever they wish. She also had to request time off in the form of holidays, and she was not able to reject offers of work when they were made. So I think you'll probably all agree that unsurprisingly in that case, Ms Gorman was deemed to have been an employee, and the tribunal did point out that at the point that she'd entered into this independent contract for services, she had been very young and unaware of her rights, and therefore it was reasonable that she hadn't quite been aware of what it was that she was signing up to, but nevertheless they deemed that she was in fact not even a worker but an employee. Okay. So that's not all that's been happening in the employment law world. We have had some really high-profile cases heard in the Supreme Court recently. We still await their judgments that can take quite a long time, but just a recap on what has been going on. The first case there is ASDA against Brearley, and this concerns a group of claimants who are female. They work in the supermarket, and they say that they are entitled to equal pay with their colleagues who work in the distribution centres. Those jobs are performed predominantly by males. So the initial question for the tribunals and the courts is, are they allowed to compare themselves? Not are they entitled to equal pay, but are they comparators for the purposes of an equal pay claim? And thus far, the courts and tribunals have all said yes, they can compare themselves, therefore the equal pay claim can proceed. The same question has been appealed to the Supreme Court, and it's for them to give us some certainty on that point. So they will decide ultimately if the equal pay claims can proceed, or they may depart from the judgments in the earlier court. So that's hotly awaited, of course, for anyone in the retail sector. I think everybody has probably heard of the Uber case at some point. It's hugely topical gig economy case involving drivers of Uber who claim to be workers as opposed to self-employed independent contractors as they are designated in their written contracts. So they say, like in the last couple of cases I mentioned, we are entitled to workers' benefits and to be protected under the Working Time Regulations, National Minimum Wage Act, etc. So thus far, the courts and tribunals have been satisfied that they are workers, and they're workers whenever they have the Uber app switched open, whenever they're within the territory within which they are authorised to work, and whenever they are sort of ready and available and willing to accept assignments from Uber. They've all been satisfied thus far that there's no sort of direct contractual relationship between Uber and between the driver and the passenger. So again, we await the Supreme Court's final say on that will have fairly significant ramifications for other businesses in the gig economy. And the final case that I want to mention to you today is Royal Mencap Society against Tomlinson Blake. So any of you out there who operate in the care sector will no doubt be aware of this case, as it concerns care workers and sleepover shifts. And it essentially asks, is it lawful to pay care workers a flat rate for a sleepover shift that falls below the national minimum hourly wage? We haven't, unlike the other two cases, the courts haven't always agreed thus far. The Employment Tribunal, Employment Appeal Tribunal said national minimum wage was due throughout the full shift, irrespective of whether the individual was awake or asleep. The Court of Appeal overturned those decisions and said no, the national minimum wage is only due when the individual is awake for the purposes of working. So again, for the Supreme Court to make the final decision on that. So we've been waiting on a judgment from that since February. This case reportedly will have a significant impact on the care sector. Reportedly, they would face up to sort of £400 million in back pay for unpaid sleepover shifts, and reportedly, unfortunately, would potentially result in a closure of many care homes. So again, another case with potentially very significant consequences. Okay, so watch this space. We will soon have some answers on those. But meantime, as Lorna mentioned at the beginning, moving on from the case section, we wanted to talk to you briefly about coronavirus. So we kind of dwelled on, we thought about, do we include coronavirus or not? Unfortunately, we can't really get away from it, albeit I'm sure that you're all very well rehearsed and probably sick to the back teeth of it. But given that it continues to rumble on, we thought, and obviously there have been recent developments as well, we thought it best just to recap on some of the key points. And at this point, I'd like to do a little poll, so bear with me and see if I can get this to work. So as it says on the slide there, almost 10 million workers have been furloughed since March, and we wanted to do a poll to understand whether or not that was something that rang true with you. So we would be interested to hear if your organisation has furloughed workers as well. So I'm just going to publish that poll now and see if you guys can give me your responses are coming in. Let me just, I don't know if you guys can see that, but we have a majority having access to the furlough scheme, and it's keeping up to over 75% now. So yeah, definitely a majority of you have access to the furlough scheme, as we would have expected. It will come to an end, as you will know, at the end of October, and I'll come on to talk about the replacement scheme in a moment. And as you know, it's been a sort of staggered scheme, and the amount reclaimable from government has already started to reduce. Third point there is that there will be a £1,000 bonus for each furloughed employee retained until the end of January, provided that individual has got a minimum level of earnings and they've remained in employment with those earnings between November and January 2021. We understand that the bonus will become payable from February 2021, which could result in considerable cost, as I'm sure many of you can imagine. The government has clarified that for the purposes of statutory payments, so statutory notice pay and statutory redundancy pay, it's the pre-furlough rate that we're interested in, so it's not the reduced furlough pay that is used to therefore calculate these entitlements for the individuals. And finally, statutory redundancy pay cannot be reclaimed under the CJRS. That's met by employers themselves. Notice pay can be claimed under the CJRS, provided the individual remains in employment throughout the notice period. Okay. Just briefly wanted to touch upon annual leave. This is one of those kind of hot topics at the outset of the furlough scheme. We didn't really know what to do with annual leave, and then finally got a bit of clarity on it, which was certainly most welcome. Employers should consider steps to ensure that annual leave is spread throughout the year to avoid a build-up. And consistent with that, many of you will remember back in March, government introduced an amendment to the working time regulations that allowed the carryover of annual leave to 2 subsequent leave years where the individual couldn't take it this year as a result of coronavirus. So it was designed for key workers like those in the NHS, but it is open to everybody, albeit it is subject to the individual's employer's agreement. We know now, this was one of the key questions, was that annual leave can be used while the employees are on furlough, albeit it shouldn't be used as an alternative. So holidays should be paid in full, and whatever applicable percentages in force at the time can be reclaimed from government up to the end of October. Arguments have been run to the effect that employees who are self-isolating should be able to postpone any pre-arranged annual leave because of the impact of self-isolation on their ability to actually enjoy the annual leave. And similar rules have been in place in relation to holidays and normal sickness absence for a number of years. And government guidance, just finally on this point, government guidance suggests that where an employee needs to self-isolate following a trip abroad, the employer should allow home working if possible, failing which annual leave or unpaid leave. We know that they're not entitled to statutory sick pay in those circumstances if until the family member has developed symptoms. But a generous employer might offer company sick pay, for example, but again, that's very much down to the employer's discretion. Finally, just on returning to work, I know that the message remains at present that home working and avoiding going back to the office should be facilitated where possible, but many of you are kind of starting to set the wheels in motion for getting back to some form of normality. So before doing that, it's worth bearing each of these points in mind. So All necessary measures must be put in place to ensure that working environments are COVID secure. So it's just a key part of the employer's duty of care and their obligation to keep employees safe at work. Furlough, home working and other arrangements might be necessary for employees with disabilities or who have other specific needs as a result of coronavirus. And employees who are experiencing problems with childcare might come on to subsequently make flexible working requests or exercise their statutory rights to time off for dependents or parental leave if furlough is no longer available to them. So we would encourage employers to make sure that they've got the necessary policies in place and that they're well rehearsed and they understand what these policies actually mean, what the rights consist of. Other legal risks include the possibility of tribunal claims for whistleblowing, so unfair dismissal claims, detriment claims, and health and safety unfair dismissals. And if you haven't already, please go on to the client area of our website and download the legal risks guide, which goes into these legal risks. They're quite complex. It goes into this in some detail. We need a full other slide for that today. And I think finally, communication is key to ensuring an effective and comfortable return to work. Let's try not to create an us and them culture. Take the employees on the journey, genuinely listen to their thoughts and concerns and try to arrive at an outcome that kind of works in both parties' interests. And finally, from me, we couldn't ignore the recent developments this week in relation to the newly announced job support scheme. So this is designed to replace the furlough scheme that, as I mentioned, comes to an end on the 31st of October. And this is unlike the furlough scheme in that the previous scheme wanted to protect employees in jobs whilst they were out of work. This scheme seeks to support employees whilst they're in work and undertaking work, albeit it recognises that as a result of coronavirus, fewer hours may be available to those employees. Okay, so it's a form of short-time working that many of you will be familiar with. It is, in a nutshell, the employee must work 1/3 of their hours and the remaining hours are split between the employee, the employer and government. It comes into force from November and we know that it will run until the end of April, albeit there might be some fine-tuning and tweaks made to the scheme as it is just now during that time. So we await further details. We've kind of got the headlines at the moment. So it's open to everyone, all employers in the UK with a UK PAYE scheme. Large employers are only eligible to participate if they have experienced an effect on their turnover, so a negative impact on their turnover as a result of coronavirus. We don't quite know what that test will look like just yet. Small and medium-sized employers are not subject to that assessment. They are eligible to participate irrespective of any impact on turnover. The employee themselves must have been in employment and an RTI submission must be made in respect of that employee no later than the 23rd of September. So for many of you that will ring bells with the furlough scheme and the eligibility requirements around that did create some problems in relation to new recruits. As I said, for every hour not worked, the employer and the government will pay 1/3 subject to a cap, the employer will pay 1/3 and the employee will essentially lose 1/3. And the employer will pay both their contribution and government's contribution to begin with and then make a claim in respect of the government's contribution. And I believe that will be made on a monthly basis. The employer, I should note, will continue to meet NICs and pension contributions. Those aren't recoverable under the scheme. Okay, so this just kind of finally for me, I think this is welcome. It was a daunting prospect that furlough was coming to an end whilst coronavirus remains, the risk of coronavirus remains present. It has attracted some criticism though from businesses and employers and sectors where, as opposed to having some work, there is no work at all, and I'm sure some of you will be able to think or may be directly affected by that yourselves. So inevitably, I think further redundancies are likely to take place. So on that note, I'll hand you back to Lorna, and if we've got time for some questions at this point, then we can have a go at them.
Yep, we do have a little bit of time for questions before we move on to the next section. So I see a couple of questions have come in there about the cases that Kirsty mentioned. So I'll address those questions, and then Kirsty, maybe while I'm doing that, you can have a look through some of the coronavirus related questions and pick up on maybe a couple of those. So one of you asked about the K versus L case, which was the one that involved the teacher who was found to have indecent child images on the laptop. And the question in particular was whether it would have been sensible for the employer to include in the invitation to the disciplinary hearing a potential alternative allegation, which is the one which relates to reputational risk. And I suppose the answer to that is relatively short, and that's yes, I do think that that would have been a sensible approach for the employer to take. It's really fundamental that whatever the outcome of the disciplinary hearing, it ties back to what was specified in the letter inviting the employee to the disciplinary hearing, because of course the invitation is designed to give the employee fair notice of what the allegations are against them. Just to give you another possibly more straightforward example, I've come across cases in the past where the allegation in the disciplinary invitation letter is theft from the till, and then at the disciplinary hearing it transpires that there isn't sufficient evidence to justify a finding that the employee stole from the till, but there is sufficient evidence to justify a finding that the employee breached cash handling procedures. However, if the alternative allegation of breaching cash handling procedures isn't contained in the invitation to the disciplinary hearing, it means that the employer can legitimately uphold that allegation. All is not lost if the employer does, at the conclusion of the disciplinary hearing, realise that they've got it a little bit wrong. They can suspend the disciplinary hearing, reissue a letter with the correct allegations contained within it, and then reconvene the disciplinary hearing. However, obviously that's a bit of extra administrative hassle for the employer, and also could be perceived by the employee to be unfair. So if you can try to, I suppose, anticipate what might come out at the disciplinary hearing, and ensure that all of the potential allegations are contained within the disciplinary invitation letter, then obviously that would be the best approach, and really the investigation report will be the key to that. And another question which arose in the context of the cases related to the Gallagher case, so that was the one involving ScotRail and the dismissal of the employee because of a breakdown in working relationships, but without the normal process that we would usually follow. And the question there was, is that potentially a dangerous precedent for the Employment Appeal Tribunal to set? And I can certainly see why that's a concern. I suppose when we look at the detail of the case, we might recognise that there is some merit in the Employment Appeal Tribunal's decision, but of course the issue is that not everybody will look at the detail, and what we don't want is for people to take the more general message from that case, that if there's a breakdown in a working relationship, we can just disregard the procedure. I think that that case very much is the exception to the rule, and of course there is the possibility that it will be appealed further as well, and that the outcome might change. So I think that was the only two cases that arose in relation, the only two questions that arose in relation to the cases. Kirsty, is there any coronavirus related questions there that you've managed to think about?
There are, yep, and thank you to those who have responded in the chat box to help other listeners, so thank you for making my life a little bit easier. One question from Claire. So for those with disabilities or former shielding reasons and furlough is no longer available and home working is not possible, what are the other arrangements? So that is a real consideration for many employers at this stage, and they have to think creatively about what they can do. And there's a big emphasis on home working, but for many of you in many industries, that just simply will not be possible. So the employer and the employee ideally will work together and communicate on what can reasonably be expected from the employee, and what the kind of future looks like. They might agree on some paid or unpaid leave. They might temporarily lay the employee off if they've got the contractual right to do that. They could take some holiday, or ultimately, actually, if there's a medical reason that renders the individual unfit to work, they may even go on to be signed off by their GP. So it's just, as is always the case when there are sort of medical considerations, it will be, you'll have to kind of judge it on a case-by-case basis. And if in doubt, there's never any harm in trying to get a medical opinion, either occupational health or from a GP, to understand, again, what are the relevant risks for that individual, and what reasonable adjustments perhaps could you make for them. Okay, and just one final question was from Alan. So, on annual leave, can we offer staff the ability to carry a week of 2020 entitlement into 2021, providing that they agree to spread and balance their 2021 holidays, perhaps even mandate that 1 week must be taken each quarter? So the short answer to that, Alan, is yes. Employers have a reasonable amount of control over annual leave. So we know, as a result of the amendment regulations from March, that employees are entitled to carry leave over for up to 2 years after the leave leave year. But it's up to employers, A, whether or not they permit that, and then what that looks like going forward. So an employer, even irrespective of coronavirus, can sort of stipulate when leave must be taken, and it must do so by providing double the length of notice as the period of leave itself. So if you want an employee to take a week's leave at a specific point in time, i.e. maybe a business closure, you have to let them know about that at least 2 weeks in advance. If you can get to the outset of the leave year and kind of timetable what that looks like, then it kind of manages the employee's expectations, and they can sort of forward plan what their sort of holiday plans are, if we actually get any. So in short, as I say, yes, you absolutely can do that.
Yeah, and there's always a bit of extra flexibility as well over any annual leave which exceeds the working time directive minimum of 4 weeks each year. The employer has more discretion to apply to that portion of the annual leave the rules that they choose to. That's great. Well, we can see that there are some more questions there. So what we'll do is continue with the rest of the webinar, and hopefully when we get to the end of the next section, there'll be enough time for us to touch on some of the additional questions that have come up there. Just before I go on to do the short spotlight on diversity, I just wanted to pick up on something that a couple of you have mentioned, and that's about availability of the slides for the session. So in advance of the session, I uploaded the slides to the files section of Webinar Jam. Now, I can see that here. However, I'm sure that you receive a slightly different version of the screen than I do. So if maybe a couple of you could have a play around with what you see and just check to see if you can locate those while I'm going through the next section. Then if you've not been able to locate those by the end, then we'll obviously see how else we can get the slides to you. Okay, so as I say, moving on now to a short spotlight on diversity in light of the Black Lives Matters movement. So we'll start off by briefly thinking about the basic legal protections which are currently available under the Equality Act. So of course, people have the right not to be directly discriminated against because of race, and that means treated less favourably than the employer treats or would treat others. And I think most employers know that that's something they're not permitted to do. And in our experience, this type of discrimination is relatively infrequent compared to some of the other more subtle forms of race discrimination. One of the more subtle forms of race discrimination, which is more common, is the right not to be indirectly discriminated against. And that means disadvantaged by a seemingly neutral policy or practice. There is the opportunity, however, for employers to attempt to justify indirect discrimination through showing that they have a legitimate aim for the policy or practice, and that the means of achieving that aim are proportionate. In other words, there shouldn't be a less discriminatory way of achieving the same outcome. And I'm sure most of you know that employees and workers have the right not to be harassed because of race, and also the right not to be victimised as a result of complaining about race discrimination or harassment. So people shouldn't be punished either consciously or unconsciously because they've chosen to pursue their rights under the Equality Act as far as race discrimination and race harassment are concerned. So these are the basic legal protections. However, I suppose what we need to ask ourselves is it enough? And what we have here is some data on how Black people in the workplace are treated and how they feel that they are treated. So you'll see the first bullet point there. Black employees hold just 1.5% of top management roles in the private sector. And we know that from a report called the Business and Community Report. And as a proportion, that's just that's an increase of just 0.1% since 2014. So not the progress that you would expect to see. However, it's even worse in the public sector, where the number of Black employees in leadership roles has remained static at 1% between 2014 and 2020. In a report carried out by the Trade Union Congress, Racism Ruins Lives, over 70% of Black and Asian workers reported experiencing racial harassment in the workplace in the previous 5 years. And nearly half of respondents said that racism affected their ability to do their job. So this isn't just a concern for those individuals who feel affected by this issue. It's a business issue for employers because, as we can see from this data, racism affects not only individuals, but also their performance, and that can have a knock-on effect on others. More than 40% of respondents who reported a racist incident said that their complaint was ignored or they were made to feel like troublemakers. And in fact, 1 in 10 of those who responded and said that they had raised a complaint went on to say that they were either disciplined or forced out of their job as a result of doing so. And the general theme seems to be that the majority of racist incidents are racist remarks and jokes, and I use that word loosely, which have some kind of racist element to them. So I think the answer to the question, is it enough, is quite clearly that it's not enough. So what can you do as an organisation in order to make some progress in this area? What we're going to do next is talk through our 8 top tips for doing more. So I'll run you through those and then we'll discuss each of them in a little bit more detail. So our first is to have an appropriate and effective training programme in place. Take steps to mitigate unconscious bias, encourage openness in reporting, appoint either diversity champions or create a diversity network, create a diversity strategy, and consider positive action, gather data on your ethnicity pay gap, and have an effective procedure for dealing with racism complaints about the behaviour of third parties. And I'll do a series of polls throughout the session just to see what steps your organisation takes in order to make improvements in this area, and that will just give us a little bit of an idea across the board of what organisations are doing what. Okay, so first of all, an appropriate and effective training programme. So there's really 3 different types of training which we would recommend that employers undertake in order to try and make some progress in this area. And I'm sure most organisations do some of this already, but I expect probably the majority don't do all 3 of these things. So it's absolutely crucial that all employees within an organisation receive equalities training, with the predominant purpose of ensuring that they understand the concept of harassment, unacceptable behaviours and conduct expected. And this really goes further than just being a recommendation. The employment tribunals expect that employers will take this step, and it can impact strongly an organisation's chances of being able to defend a harassment claim. You'll have heard in the past, I'm sure, employees explain when they are accused of harassment that they didn't mean to cause offence. What they were saying was just banter, they were just having a laugh. Those are really common explanations that employees provide, and this type of training really makes it hit home to employees that those are not excuses and it helps them to understand where that elusive line is between a laugh and a joke on one hand and unacceptable harassment on the other hand. All employees should receive that type of training, managers and those without any management responsibilities. However, on top of that training, there is additional training that managers should receive. They should understand how to identify discrimination and harassment and how to tackle it when it does arise. And that will involve understanding how to deal with complaints about discrimination and harassment. And it is really important that employees who hold management responsibilities understand the sensitive nature of harassment in particular and have the suitable soft skills in order to be able to address complaints in an empathetic way. Another type of training which I think is important for managers to receive is training on diversity and unconscious bias. And we'll talk a little bit more about unconscious bias next. And then finally, if you do have diversity champions or a diversity network, then it's important for those individuals to also receive some training so that they can effectively undertake their role and also support their colleagues. Okay, so step 2 is take steps to mitigate unconscious bias. Unconscious bias is a really, really interesting topic, and I could probably talk about it all day. It's one of my real interests. So important to recognise that we all have unconscious bias. Every single one of us have unconscious bias about something. And unconscious bias is something which has developed in our minds over the years as we've been exposed to advertising, to the media, and even just to the views of our families and friends. What's important is that we all recognise that we have unconscious bias and that we take steps to mitigate against it. And that is particularly important for managers who make important decisions on a day-to-day basis. What we mustn't have is unconscious bias being allowed to influence those decisions. So that's, of course, where manager training is really important. So I want to just pause there and find out how many organisations carry out unconscious bias training for their managers. So let me share the poll on that. Okay, so you'll see what I'm asking there is, do you do the training? And if you do, could it be more effective? Okay, so I think we're kind of roughly settling there on round about between 70 and 75% of organisations not doing any unconscious bias training for their managers. Round about 10% do unconscious bias training, and then round about 20% do it but feel that it could be done more effectively. So there's an action point that a lot of you can take away from today. And obviously this is something we can help with if you'd like some further information on what we can do to support. Another common mitigator includes eliminating unnecessary information during the recruitment process. And this is a really important one that I think lots of organisations have been developing in recent years. So taking off, for example, reference to people's dates of birth on application forms and trying to think what more can be done in order to ensure that at the very initial stages of the recruitment process, those who are doing the shortlisting are not being influenced by their unconscious bias, therefore excluding certain groups of people from the remainder of the recruitment process. And I'm sure you'll have seen some of the experiments that have been done in this area. For example, a number of years ago, I think it was Time Out London did an experiment where they sent off 100 application forms in the name of Adam, and then 100 application forms in the name of Mohammed, and largely the information contained within those application forms was the same. Adam received 12 interviews as a result of those 100 applications. Mohammed received 4. And really the only explanation for that was the difference in their names and obviously the connotations associated with the names. The next point, robust and objective decision-making processes backed up by effective paperwork and record keeping. I'm sure sometimes when managers do recruitment processes, they perhaps get a little bit frustrated at what seems like having to kind of jump through hoops insofar as paperwork and record keeping is concerned. But really, these processes and paperwork are in place in order to encourage objective thought. If we don't have these processes in place, then of course there is a greater chance that managers will be influenced by their own subjective opinions, which in themselves might be influenced by unconscious bias. Allow time for decision making. Our unconscious bias plays its biggest role in our decision making process when we're forced to make snap judgments and quick decisions. And I'm sure in the past you've perhaps been tempted when arranging interviews to cram them all into one day without very little in between them for discussion and reflection, because of course carrying out a recruitment process is in addition to your normal day-to-day tasks. So it's understanding why managers are tempted to do that, but the risk is that you're not then taking the time which is required to reach objective and reasoned decisions, which again increases the likelihood that unconscious bias is allowed to creep into the decision-making process. And encourage open discussion and polite challenge. So if, for example, you are sitting on a recruitment panel with somebody and they perhaps express a conclusion which you don't agree with, I'm not suggesting that you call them racist or sexist or homophobic, but what you might ask them to do is just to explain a little bit more about the factors that have led to their conclusion, and that then causes them to reflect on their view and perhaps at that stage to identify whether they've been influenced by anything which they shouldn't be. Okay. So tip number 3 is encourage openness and reporting. So don't shy away from discussing difficult topics, and those could be topics that are related to race or other difficult topics, things like mental health and menopause, because by showing that as an organisation you're willing to discuss these difficult taboo topics, it shows that you're open to people sharing their experiences of racism with you. I always recommend, as a matter of course, I think at almost every training session that I do, regardless of the topic, that managers keep in touch with employees through one-to-ones. And sometimes managers will say, well, I don't need to do one-to-ones because my employees know that my door is always open and that I'm happy to speak to them if they have any particular concerns. But my message would be that that's not enough. Yes, you will have some employees within your teams who are confident and who will be vocal about any concerns that they have. However, equally, you will have, I'm sure, a number of other employees who wouldn't proactively come to you if they had a concern. However, if you were sitting, well, okay, I was going to say sitting around the table with them, which you may not be at the moment, so perhaps you're on a Zoom call with them or something like that, and you specifically ask them the question, how are you? Then it may well be they would be more inclined to disclose to you if they had any particular concerns of racism. And actually, I would say that this is even more important at the moment when we don't actually have the opportunity in many workplaces to be having casual face-to-face conversations. Another option which employers can give to employees who have concerns but perhaps who lack the confidence to express those is to put in place alternative reporting channels. So, for example, an online or anonymous reporting system. Clearly, receiving an anonymous complaint of racist behaviour is a little bit more challenging than if the complaint is named and provides more specific information. But I suppose the idea is that it's better to have some information than it is to have none at all. So if the alternative was that the person simply wouldn't come forward with their concerns, then receiving some information through an anonymous reporting system will at least allow some action to be taken, albeit limited. You can monitor engagement and identify issues through a staff survey or a focus group. And one of the important points which came out of the Equality and Human Rights Commission guide, which was published earlier on in the year, was to ensure that if you are doing a staff survey, your questions are sufficiently detailed for the information that you receive to be useful. So it wouldn't be enough to just ask, have you experienced any harassment in the workplace? Because employees often don't understand the types of behaviours which amount to harassment. Instead, a series of questions could be asked. So, for example, have you experienced any unwanted racist remarks? So actually breaking down the different types of behaviours which amount to harassment in order to make the information that you get back more useful. Encourage people to share experiences in order to promote understanding. Obviously, if you have yourself never experienced any racist behaviour or discrimination, then it's unlikely that you will have a full understanding of the impact that that can have on people. So understanding what other people experience is really good in order to just try and increase your knowledge in this area. As I mentioned in relation to the last slide on unconscious bias, don't be afraid to politely challenge the decisions of others. And obviously ensure that complaints are treated appropriately and with empathy. Earlier on in this section, I mentioned some statistics that relate to employees who felt that they were punished as a result of raising claims or concerns about harassment. Obviously, really important that people are not made to feel like that, or else it will be off-putting when it comes to raising any further concerns. We quite often hear people report that when they raise concerns about racist behaviour, they feel that they are treated in a hostile way. And so obviously we must make sure that that's not the impression that we're giving to people who raise concerns. Okay. So just another little poll now, just to find out if your organisation has an online or anonymous reporting system for harassment in place. So I'll start that just now, and I think I've just worked out actually how to display the results at the end of the poll, so hopefully this time those should come up for you to see. Okay, so I'll just end that there. So we're kind of hovering between around about 20 to 25% of employers having one of these systems in place, and then the remaining kind of 75 to 80% having no system like that in place. So again, that's another action point for you to consider, particularly given the recent developments in relation to sexual harassment. This is a really good tool in order to identify issues which you might not otherwise be aware of. Okay, thank you for that. Okay, so our number 4 tip, appoint diversity champions or create a diversity network. So diversity champions can support employees in raising concerns or making complaints about discrimination or harassment. So really they can take on some of the responsibilities that a trade union representative might if there was a trade union active within your workplace. A diversity network can provide a safe space for employees to discuss their challenges openly, and the organisation can also discuss with the diversity network ideas for improving diversity. However, it is vitally important, and I can't emphasise this enough, that diversity networks are sufficiently resourced and not a token measure. So it is really important that in order for the network to be engaged, it's assigned a sufficient budget, resources, authority, time and support. If the network doesn't have these things, then it can actually be more damaging than a positive experience, because people will feel that it's simply in place so that the employer can tick the box, but without actually any real support behind it. So I'm going to share another poll now just to try and get a gauge of how many organisations currently have diversity champions or a diversity network. Okay, I'll end that there. So it's pretty similar to the answer to the previous question. It was hovering there between around about 20 to 25% of employers having diversity champions or a diversity network versus around about 75 to 80% answering no. Okay, so number 5 is create a diversity strategy. So what's involved in that then? Usually the starting point is to analyse the composition of the workforce to identify underrepresentation generally and or at particular levels or within particular roles within the organisation. Then consider what barriers are faced by the underrepresented groups. And then finally consider lawful measures for removing those barriers. So we'll just have a look at a couple of examples. And this is obviously just really distilled down to the key points. There's a lot more involved in it than perhaps what I'm making it sound like here. Okay, so example number 1, an analysis identifies that there's an underrepresentation of Black people in the workforce generally. So the diversity network suggests that roles within the organisation may not seem accessible to people within this group. So the output is to consider how accessibility could be improved. For example, partnerships with schools, colleges and community groups in areas with a high population of Black people. And then example 2, an analysis identifies that there's an underrepresentation of Black people in senior roles, and obviously we identified that research shows that that is the case across both the private sector and in the public sector. The diversity network suggests that the lack of senior Black role models within the organisation could put Black people off seeking promotion. And so the output might be consider an internal campaign to highlight the senior Black employees that do work for the organisation, and or to consider positive action when recruiting into senior positions. And we're going to think a little bit more about positive action shortly. So I'm going to share another poll now. You've probably gathered that I got quite excited when I identified the polls function, which is why I'm asking you so many questions. Okay, so does your organisation have a diversity strategy? Okay, I'll end that there. So again, we have around about 75% of employers saying they don't have a diversity strategy, 13% saying they do, and quite a large proportion, 13% saying they do, but it could be more effective. So I suppose that again recognises some of the points that we've talked about already. Often there will be measures in place, but they perhaps won't go far enough or won't be effective enough. Okay, so I mentioned the words positive action there, and sometimes there's a little bit of a misunderstanding about what positive action involves. So important just to make it clear from the outset that positive action is lawful and is not the same as positive discrimination, which is unlawful. Positive action is not compulsory, but it can be a very powerful tool. Positive action can generate nervousness and debate, and we're going to come on to look at an example of that in a moment, but sometimes bold action is required to improve diversity. So it might be that an employer tries a range of different options, none of which are effective enough to make a real difference, and therefore positive action is the bolder alternative which we considered at that stage. There are 2 types of positive action: general positive action and positive action specifically in relation to recruitment and promotion. So we'll talk about those in a little bit more detail. Okay, now apologies for the amount of text on this slide. There wasn't really any other way to get the message across, but there will only be a couple that are this text heavy. So first of all, the general positive action provisions, and these are contained within the Equality Act. So the ability to take positive action in a general sense applies where the employer reasonably thinks that people with a protected characteristic suffer a disadvantage connected to the characteristic, or people with a protected characteristic have different needs from others, or participation in activities by people with a protected characteristic are disproportionately low. Now, just for those of you who are not familiar with what we mean when we talk about protected characteristics, those are the personal traits which the Equality Act prevents employees being discriminated or harassed because of. So race is an example. Other examples would be sexual orientation and religion and belief. And I should have said that when I was talking about having a diversity strategy, we are looking at it today in the context of the Black Lives Matter movement, which is why I've made reference to race. However, a diversity strategy will usually cover all of the different protected characteristics and also some additional factors, so maybe things like socioeconomic status as well. So if one of these different criteria applies, then the employer can take proportionate action to enable or encourage people with the protected characteristic to overcome or minimise the disadvantage, meet the needs identified, or enable or encourage people with the protected characteristic to participate in the activity. I'll come on just to talk you through a few examples from the Equality and Human Rights Commission's code on this topic. But I'll just briefly mention, first of all, what we mean when we talk about proportionate action. What that really means is that it's important when the employer is thinking about all of the different options available for meeting the issue which has been identified, which out of those is likely to be effective, but also which option is the one which is least likely to impact negatively on other groups. So here are a few of examples of general positive action from the Equality and Human Rights Commission's code. So providing bursaries to obtain qualifications in a profession for members of a group which is underrepresented. I think I read a few years ago that EasyJet had provided bursaries to a number of women who aspired to be pilots, given the enormous underrepresentation of women in that profession. Reserving places on a management training programme for those from a group which is underrepresented in management roles. So obviously that's a very, very relevant example for Black people, given the data that we've considered already. And providing mentoring or targeted networking opportunities. So let's just look at a recent example that I came across. And this is an online poster which I pulled off of Facebook, and you might not be able to read those words because they're pretty small, but this was as best as I could get it. So I'll read out the first paragraph there in case you are struggling to read the words. So it's headed aimed at our increasingly diverse BME population. Police Scotland is acutely aware of the diversity of our communities is increasing all the time. We recognise the importance of our communities being able to relate to our police officers, and we are therefore actively reaching out to our BME community and encouraging you to consider a career in policing in Scotland. So this event has obviously been created in order to try and increase the proportion of the police force which comes from a Black or minority ethnic background. Now, what I'm going to do next is just share with you the kind of blurb which was associated with this event, and also a comment which was posted by just a member of the public in the comment section under this advertised event. And it's a comment which reflects quite well some of the attitudes which are out there to this type of measure. Okay, so you'll see there that Police Scotland clearly decided that it would be sensible to put a precursor to the post, which was that Police Scotland are actively recruiting people from all backgrounds, and then going on to say, to encourage applications from underrepresented groups, we will also be holding an online recruitment information event aimed at BME communities. So the police was clearly trying to make it clear there that whilst there is more general recruitment occurring, there is a specific focus on encouraging people from BME communities which are underrepresented to apply. So you'll see there a fairly typical comment. It's okay to discriminate against white people. What a nonsense this is. Imagine what would be said if it was aimed at recruiting more white people. This is a disgrace, and it's no wonder the police have no respect from the public. Obviously, this is not my view. This is just a comment from a member of the public, and I just selected this one because it's fairly representative of some of the attitudes that you see expressed in relation to this type of intervention. Now, of course, an event which was designed to encourage white people to join the police would be unlawful because there is no underrepresentation of white people within the police force in Scotland. So important to recognise that the purpose of this type of event is to try and redress an imbalance which exists. And I'm just going to show you another little slide here, which hopefully helps to depict what this is all about. So in the first diagram there, you'll see that you have people being treated equally. In other words, they all have the same size of stool, but the outcome is unfair because only some of them can see over the fence. So that's where we get to if we treat everybody equally. And then in the second diagram, we have the stools being reallocated. And the result of that is that each person can now see over the fence. So this is what we would think of as being equality of outcome. So it recognises that people have different barriers, and if steps can be taken to try and take away or mitigate those barriers, then we're more likely to result in fairness and equity. There's some really interesting stuff online about the role that lack of diversity within the CIA played in the failure to identify and prevent the 9/11 terrorist attacks. And on a similar theme, the organisation which is tasked with preventing terrorist attacks in this country, MI5, have gone through a process of trying to improve their diversity, recognising that a lack of diversity can hamper their effectiveness. Okay, and then just a few final points in relation to positive action, specifically in relation to recruitment and promotion. So this applies where the employer reasonably thinks that either people with a protected characteristic suffer a disadvantage connected to the characteristic, or participation in activities by people with a protected characteristic is disproportionately low. So the employer can take proportionate action with the aim of enabling or encouraging people with the protected characteristic to overcome or minimise the disadvantage, or enable or encourage people with the protected characteristic to participate in the activity. And I'm going to explain this a wee bit in a wee bit more detail. The permitted action is treating a person A more favourably in connection with recruitment and promotion than another person B, because A has the protected characteristic, but B does not. Now, I appreciate that's a lot of words and there's some legal terminology used there, so I'll just try and explain that in a way which is a bit more understandable. So essentially, these provisions apply in almost a tie-break situation. So where you have two candidates for either a role or a promotion, and they've scored equally in the sense that they're both as qualified as each other, but one comes from an underrepresented group and the other does not. In those circumstances, the employer is able to select the candidate from the underrepresented group. As I said, A must be as qualified as B, and sometimes a little bit of confusion can arise as to what do we mean when we talk about as qualified, because obviously in normal recruitment processes, the decision doesn't just come down to the formal qualifications that the candidates have. There's more to it than that. This will be interpreted in a wide way according to the Equality and Human Rights Commission. So it won't just touch on formal qualifications. It will also allow employers to think about previous experience and other attributes that the candidates may have which are desirable or essential for the role. So just to give you an example from the Equality and Human Rights Commission's code, the example involves a counselling service which works in an area with a high proportion of Muslim people, or a high population of Muslim people. At the moment, the counselling service doesn't doesn't employ any Muslim call handlers. So if faced with a recruitment process where two candidates scored equally and one was Muslim and one wasn't, then the employer would be justified in recruiting the Muslim candidate, because that's seeking to try and address an underrepresentation of people from that group. It is important and required that the employer doesn't have a policy of treating people with a protected characteristic more favourably in connection with recruitment and promotion. So it can't be a blanket policy which is applied across the board. It must be aimed and targeted at specific processes. And again, the taking of the action must be a proportionate means of achieving a legitimate aim. When it comes to assessing whether a particular group is underrepresented, there is some evidence required from the employer, but it doesn't need to be detailed statistical evidence. And also important to remember that when you're assessing whether a group is represented sufficiently within the workplace, you take into account the local population and the demographic of the local population. So, for example, if 5% of the workforce is from a Black or minority ethnic background, that probably wouldn't be an underrepresentation in a workplace in Inverness, but it would be in a workplace in London. So I'm going to share another poll now just to find out whether your organisations, or whether you're aware of your organisations using positive action as a tool to try and address imbalances in the workplace. I suspect that it will be a minority of employers who have done this. So here we are. Let's see. Okay, aligned that there. So yeah, 93% of employers haven't used positive action, and only a very small amount have. And that's not an unexpected result. As I said earlier on, it's not compulsory, and it does generate some nervousness and some debate. However, if your organisation does lack diversity and previous efforts to improve the position haven't been effective, then perhaps this is the next step, which is worth considering. And I would always recommend that if you are considering positive action, that you take advice in order to make sure that you don't fall foul of the rules, because they are quite narrow. Okay, so two more top tips. Number 7 is gather data on your ethnicity pay gap. So some of you might recall we've spoken in the past at our employment law updates about a government consultation on mandatory ethnicity pay gap reporting. That closed in 2019, in January, in fact, so quite some time ago, and there's not been any further activity. And the idea was that mandatory ethnicity pay gap reporting would be similar in some ways to the current mandatory gender pay gap reporting rules. The BLM movement has prompted calls for the government to make this a priority, and just over the last few weeks, a petition has reached over 100,000 signatures, which means that there will be a parliamentary debate on this topic. However, employers, particularly large ones, might see the benefit in collecting this data voluntarily now to try and understand the causes of any racial inequality, and to allow them to include appropriate steps to address it within their diversity strategies. And in fact, a recent survey by PricewaterhouseCoopers found that 23% of employers now calculate their ethnicity pay gap, which has increased quite significantly from just 5% in 2018. So that shows that this is something which is more and more on the radar of employers, probably predominantly larger employers. I suppose the idea is, why wait until this becomes mandatory? If we can gather some useful data from this process, then we can just get started with it now and make some real progress in this area. And so I'm going to find out again whether your organisations do this at the moment. Okay, so this question is, does your organisation gather data on its ethnicity pay gap. And so you'll see there are only 2% of employers that do that currently, and then another couple of % of employers who do that but feel that it could be more effective. I was going to ask a follow-up question, which was, if you do gather data on the ethnicity pay gap, do you publish it either internally or externally on your website, for example? But given the very low positive response to that question, I don't think I'll bother asking that follow-up question. And then finally, have an effective procedure for dealing with racism complaints about behaviour of third parties. This is really important because the Equality and Human Rights Commission Turning the Tables study, which was conducted last year, identified that just under a quarter of respondents had been harassed by a third party. I think that was a much higher proportion than what we might have expected. And just to be clear, when we talk about a third party, what we mean is somebody who isn't the colleague of the person. So it might be, depending on the context, a customer, client, service user, pupil, patient. And so because of that relatively high prevalence of third party harassment, it's really important that employers ensure that their employees are absolutely clear that they have their support should they be subjected to any racist behaviour from third parties. And organisations should have appropriate policies and procedures in place to deal with third-party harassment, and those should be effectively communicated to employees. And obviously the type of action that an employer would take in the event that third-party harassment occurs is very dependent on the nature of the third party. So if it was, for example, a customer frequenting a shop, the type of action that the employer might be able to take would be very different to if, for example, it was the finance director of one of our major clients. And complaints should obviously be taken seriously and not trivialised or dismissed. So sometimes there can be a temptation to treat complaints about harassment which has been perpetrated by third parties less seriously. Some employers may even think that employees should be prepared to put up with a certain level of harassment because it comes from an important customer or client. So really important that we don't fall into the trap of trivialising that type of harassment. Okay, so having gone through our 8 top tips, we'll just briefly think about what benefits you will reap from having a diverse workforce. And really, for me, the most important one is the level of creativity and innovation which a diverse workforce brings. Study after study has shown that diverse workforces are the best performing workforces because different life experiences and different perspectives drive creativity and innovation, allow employers to introduce new products and services. You'll have improved staff engagement, and as a knock-on effect, fewer disciplinary and grievance issues. Working with people from different backgrounds and cultures is also really positive from a personal development point of view. You'll gain the respect from customers, and I know that particularly down in London, a lot of organisations who are carrying out tender processes in order to bring on, say, a law firm will actively consider the diversity of the various law firms that have applied for the position. And then you'll also have better recruitment results, because if you are selecting from a more diverse pool, then you have a wider selection of candidates to choose from. But what's really important is that creating a diverse workforce is a continuous process of improvement. It doesn't happen overnight. And it's important as well that it's not a one-off initiative. A lot of organisations make a big fuss out of creating and launching a diversity strategy in order to kind of reap the reputational and PR benefits that that brings, but then actually don't do all that much in the way of tangible action to improve diversity. So really important that you don't fall into that trap, because actually creating and launching a diversity strategy in a very vocal way, but then not actually following it up with any tangible steps is likely to be more damaging than it is to be positive. Okay, so that takes us to the end of that section. And just before we take some final questions, I just wanted to update you, I suppose, on what we are doing in terms of our traditional in-house training, which is where we train managers on various HR, employment law and management topics. So for obvious reasons, we're restricted from delivering face-to-face training in a lot of workplaces at the moment. However, we are very successfully delivering virtual workshops to groups of managers and employees. And we're doing that using platforms such as Microsoft Teams and Zoom. I'm sure you're very familiar with these now. And we're able to still create engaging and interactive training with polls and case studies, etc. You've seen today my newfound passion for polls. And a new topic that we've just introduced fairly recently is managing employees who are working from home. So if you think that topic or any other HR, employment law or management topic would be of interest, then you are welcome to contact me to discuss what we can offer. And then insofar as e-learning is concerned, we work in partnership with an e-learning partner called Bolt Learning, and our clients benefit from substantially discounted rates. And we offer a package of £30 plus VAT per employee per year for 3 high quality modules, and there's around about 80 to choose from, and not every employee has to take the same 3 modules. We're very flexible as to what we offer, and if that's of interest, then you can access a free trial on the website, which I've mentioned on the slide there. And again, if you want more information, you're able to contact me, and I'll do my best to answer your questions. Okay, so just have a little look now at the chat section just to see what we can cover off in the last few minutes.
So a couple that have come in relation to the section that I did earlier. Firstly, from Lorna, what constitutes a large employer? So that's a really good question. It hasn't specifically been addressed in the JRS fact sheet or information, but we kind of assume it will be the sort of normal definition of large employer that's applied. So in the UK, typically an SME or a small to medium sized business will have a turnover of less than 25 million or fewer than 250 employees, or gross assets of less than 12.5 million, or a combination or two of those 3. But again, much like the remainder of the JSS, we do await further information. Keep an eye on, if most of you hopefully will be signed up to Law Mail, which is our kind of monthly bulletin, but we have throughout the coronavirus pandemic been sending out kind of more pressing updates when they've arisen, and you'll have access to hopefully our coronavirus resource centre that's updated live as and when the more information comes to light. So do please keep an eye on that and sign up to the email updates as well. Another question from Nisa was, what do we do about untaken holidays? And again, that's another good question. First and foremost, the employer should, where possible, try to ensure that employees are taking sufficient levels of annual leave. Working time regs are primarily a health and safety piece of legislation to make sure that everybody is adequately rested from work. There will, of course, be circumstances where it's, individuals either have not chosen to take leave or they've not been able to. So try and work together if you can and create a plan to get the start tapping into the accrued leave to avoid it building up to an unmanageable amount. Employers are not allowed to pay in lieu of annual leave other than when the employment terminates. So don't say, come December, you've got 10 days outstanding, we'll just give you an extra 10 days or 2 weeks pay. That's not what the working time regs are there to do. Some employers will take a fairly harsh approach, sort of use it or lose it come the end of the relevant annual leave year, or they will dictate that only X amount can be carried over for a finite period of time. But as I say, try and work together. Ultimately, the employer can designate periods of leave, provided it gives double the length of notice as well. So hopefully the amount of leave lost, if you like, will be kept to a minimum. Okay.
I'll just pick up on just one or two points there in relation to my section. So somebody asking, how do you calculate ethnicity pay gaps? So I mentioned earlier on that there was a government consultation on this, and from memory, I think the government had suggested the alternative ways in which an ethnicity pay gap may be calculated, and the idea was to get feedback from businesses and other interested parties on which of the three might be the most effective. So there is no set way at the moment. From memory, there was discussion about whether it should be a very broad calculation or whether it should be broken down into different ethnic minority groups. But I know, I think that question is from Letitia, and I know that we work with you, so I'll see if I can provide some follow-up information on that, just directly to you. And then just another point, a couple of people there saying that there's been some suggestions that unconscious bias training is not particularly effective in the longer term. So my own view on that is that unconscious bias is a really useful tool, but not on its own. So it has to be accompanied by other mechanisms. Training on its own, whilst really useful, obviously it needs to be backed up with other things, or else it can be seen as just a bit of a token effort. So I would say that that's one useful thing out of a package of various interventions. Hopefully you've got some useful tips there today on how you can improve diversity. What came out from the polls was that there's certainly some work that can be done within a lot of organisations to try and improve diversity. So hopefully you'll be able to leave today with some ideas as to how you're able to do that. We're not actually sure how we get these slides to you using Webinar Jam. I wonder if what might happen is some kind of follow-up email is generated with the slides contained in it. So I'll certainly find out, and if that's not the case, then we'll circulate them to you in some other way. So thank you very much for your attention today, and hopefully we'll see you either face-to-face or, if not, in this format again in the spring. But do contact me if you have any questions at all about what we can offer in terms of other types of training.
Thanks, everyone.
Thank you.
Bye-bye.
Thank you.
Bye-bye.